will be interested, but I actually instigated Stuart Wheeler's challenge, or initiated it, by writing to him because I wanted money, or to set up one of the things that I've envisaged is this whole problem of money. And it's always seemed to me that dream world it might be, but if you don't dream high, you won't get there. And I thought that if there was £100 million tucked into a fund, you could set up a system whereby you had a pension fund, in effect, that didn't have to keep going cap in hand all the time back to the people for more money, and that it would be big enough in order that it could finance specific attacks on policies that were contrary to our constitution. Now, £100 million is an awful lot of money in private hands. It's not so much money in the corporate world. And I've always wondered whether it might be feasible somehow to accumulate an enormous fund that could then become self-financing. And I wrote partly with that in mind to speak to Stuart Wheeler about, he having been very successful in his business, and also mentioned the fact that I and John Greer, who I worked closely with, and Norris McWhirter, of course, in the past over the Nice Treaty, and the attacks in the court in the Nice Treaty, with Lear Lynn Price. And I said that we were hoping to do something over the Lisbon Treaty. And anyway, it transpired that we had some meetings, and we had meetings with Lear Lynn Price, the QC, and it was held that we would take forward an attack on the Lisbon Treaty on the basis of a challenge to the sovereignty of Parliament versus the rule of law, because that's the contest that we need to have. And anyway, it was agreed that we would do it, and money was forthcoming, and so it was all going ahead. I attended a meeting at which it was all duly organised, and that then solicitors would be employed to formally instruct the QCs and so on. And at the following meeting, at which I wasn't attending, it happened overnight. We had a meeting on a Sunday, and on the Monday there was a new meeting at which I wasn't present. And Leo Price had in fact been removed from the proceedings. The case had been changed from one of an attack on sovereignty to one on the basis of not having a referendum. And therefore it was about contract law rather than about constitutional law, yes, as far as we were concerned. I was bitterly disappointed that this had happened, and of course we weren't paying the piper, so he who pays a piper plays a tune. And somehow, and I don't know how, but somehow Stuart Wheeler had been talked into changing his mind about what the court case should be. But that's aside, it went ahead with a different QC, whole different case. It's very interesting, but it wasn't the case that I wanted to bring. And certainly as far as the initial idea and the challenge on the sovereignty of Parliament issue is concerned, there was to be, I think it would have been a very good case indeed. It would have been we were getting back to the first principles of governance, and it'd be very difficult to argue that there was a right within government to give away powers to a foreign authority. So that's what actually happened. Well, here we are. We've got to get the next one going. Just for what it's worth, in the first case of the Nice Treaty, in 2003, I think it was, Lord Justice Pill commented to Mr. Price, who was making a case for us. He said that, "Oh, I hope you're not going to impugn the sovereignty of Parliament, Mr. Price," leaning over the podium. And of course, Leo backed off a little bit at that point, because he was trying not to get into too confrontational situation.
Yes.
And in our subsequent meetings at the second time, I said to Leo, I said, well, you know, we really possibly lost the case then, because would it not have been better if you'd actually jumped down Lord Justice Pill's throat at that point and said, actually, look, we have to get back and discuss the sovereignty of Parliament and the rule of law, because that's where this whole thing is going wrong. Leo looked up and commented and said, Dicey's heresy. And for those of you who don't know, but Professor A.V. Dicey wrote the phrase that said that Parliament can make or unmake any law. And that has been taken to assume, to a level to assume that Parliament can do as it likes. That wasn't what Dicey meant, and it wasn't what it ought to be. Anyway, Leo has, owing to my booklets and so on, said that he's now a reconstructed Dicean, and so he believes that there has been things. And if you're interested in all this, the Countryside Alliance case in 2005 is very interesting, because the judges say that yes, they recognise that Parliament's sovereign, that's where we are today, but they also comment that it's judge-made law, it's only come out of the court cases, and that the thing is beginning to weaken, and it is beginning to change. And it's quite obvious that if we have constitution and constitutional law, then that must limit and control the executive. And I will just leave you with one last thought. Dicey actually wrote in his book on the constitutional law an interesting statement. He said that the difference between the droit administratif, which is of course the system on the continent, which is an administrative system and top-driven, and the rule of law is this, that under the droit administratif, the judges are only responsible to the executive. But under the rule of law, the judges are responsible to the rule of law, and thus the executive is accountable through the judges and the law to the people, or through the people's court, should I say, to the people. And Dicey made that perfectly plain, and so he expected, at the end of the day, that the law should be obeyed.
But isn't it
So that was my 10 pennyworth.
Isn't it a fact that if government makes a bad law, it can be repealed? Hence the poll tax situation. There's a lot of legislation comes out of Parliament which is absolutely waste of time, and lots of people are sort of fed up with some of the legislation that comes out of Parliament. But it can be repealed and it can be changed. And as I use the example of the poll tax.
Yeah, this whole business about whether Parliament can change laws or alter laws is very important, but it's actually a little bit of a red herring, because all of the laws that we need to support our Constitution are fundamental documents. There's our Declaration of Rights and our Bill of Rights, and I think I've got a picture in here, certainly in my presentation that I do on this. All the law is current statute law. So whether it's irrepealable or for all time to come, it doesn't actually matter. It's actually currently in the statute book. And I believe that it goes far wider and has far greater bearing than the people at the moment have been able to bring to bear. And to this end, I always say to people that if you gave me 5 or 10 million quid, I believe that I could go a long way to solving the problem of the EU. That may not be right, but I do believe that what one would do is you could bring it up, you could address it in the courts on a consistent and continuous basis with that money, and bring some very interesting cases to light, which would at least raise the heat on the whole question. But whether the judiciary and everything, whether it's all gone too far, is of course the $60,000 question, isn't it?
Absolutely.
Now, if we're going to be fortunate enough in hearing our friend give a proper expose in the new year, so put that down. You
October.
In October.
October, yeah.
We'll sort that out. Yeah, there's a okay.
You've agreed to come in October.
Well, it was not down to me.
Between our common law, which has just been discussed, and the European law. It's a very important thing, because this country is famous throughout the world for our common law, whereby, simply put, a man is innocent until he's proven guilty. So you can't be arrested and thrown into prison for months on English law. But on European or Napoleonic law, you are guilty of any crime they want to put before you, and they can put you in prison for as long as they need until you prove yourself innocent, which is rather different. That's a basic difference. But coming to the law itself, there is nothing better in this world than English law.
It's all about intent, of course. I mean, that's the
Yes.
whole point. It's not about the letter of the law, the letter of the administrative issue. It's about intent, and that's a question of whether the people decide that the intent was there, not the state.
On the subject of the law, I believe that Bill's got a question.
Question, John.
Coronation oath, actually, within this document, Her Majesty's coronation oath. I've got there. There's a, but I've got there's a letter this is a very interesting letter here, which again comes up in my presentation, and what it is it was that my MP back in 2000 was Howard Flight, and I wrote to Howard Flight and asked if he would ask a parliamentary question, because I was probing this whole business as limitations of power.
Was that why it was there?
No, I don't think so. But I think he fell out with Michael Howard on that one.
Yes, yes.
But no, so to probe the issues as to power, and therefore I wanted to find out whether there were any actual limitations to Parliament's power. So I thought, right, well, the very best thing to do is to ask the first primary question, is can they recommend a breach of the coronation oath? Because that seemed to me to be a terrific starting point. So I got Howard Flight to write a question, or to ask a question, and it was a written question, and he put it to Downing Street. And Downing Street found it difficult to answer, quite extraordinary. So Mr. Blair had Jan Taylor. The Prime Minister has asked me to arrange for a minister in the Home Office to reply to you direct. Well, the minister in the Home Office at that time was Jack Straw, and he did reply. Well, we got rather a good reply from him, because you see, we've pushed him back to the rack of first principles.
Ex-communist.
Yeah. I can confirm that the coronation oath is a solemn undertaking by the sovereign and is regarded as binding throughout her reign. Her Majesty would not be advised to give her assent to a provision which contradicted that oath. That's not bad, is it?
No.
So I thought, terrific. We've got the first limitation here. Here's something they can't do. Binding throughout her reign.
That's very good.
And so from that I have worked up a whole case, in effect, which has never yet been heard. But there's some other very interesting things. I'll read you just, if you look in parliamentary practice, Sir Erskine May, this is a book, it's actually Parliament's very own handbook. And I used it on the front of this little document I've written up called Unlawful Governance. But in Erskine May, he talks about limitations of power, and it says, the Act of Settlement affirms that the laws of England are the birthright of the people thereof.
Right.
And the kings and queens shall ascend the throne of this realm, ought to administer the government of the same according to the said laws, and all their officers and ministers ought to serve them respectively according to the same. The succession to the Crown Act 1707, this is terribly interesting because of course this was a time of Jacobite rebellions and so on. And so it said, declared it high treason. High treason. There's a sort of nasty penalty for high treason. Absolutely. For anyone to maintain and affirm, by writing, printing, or preaching, that the kings or queens of this realm, by and with the authority of Parliament, are not able to make laws and statutes of sufficient force and validity. Listen to that. Not able to make statutes of sufficient force and validity, to limit and bind the crown. Terrific that, isn't it? To limit and bind the crown, and the descent, limitation, inheritance, and government thereof. So if you preached or printed articles to say that that wasn't so, in the past it was high treason when it suited the government over the Jacobite affairs. Well, they only repealed that law in 1967. Or that part of the law, and they repealed it with the treason, with the Criminal Justices Act against hanging. So that was the only reason that bit went down. But the principle is perfectly clear. The principle hasn't been changed, and the principle is that the constitutional law plainly limits and binds the crown and the government thereof. Therefore, I think we can rest assured that our Bill of Rights and our Declaration of Rights and the Act of Settlement are acts aimed directly at controlling the use of prerogative power. They have very great bearing on what the Crown ought to be able to do. Anyway, there you are, there it is.
Well, we should looking forward to hearing a clear statement on this.
Sorry, it's going on.
Yes. There's one other thing I wanted to mention. The name of Norris McWhirter came up. Norris McWhirter, a very fine man, produced a newspaper called the Westminster. Gazette, I think it was, which is one of the original newspapers which actually told the truth. There are not many newspapers which do, because, as I told you, in America they're all under control. In this country, they are also pretty well under control. That's why you don't hear the newspapers and the BBC talking about the European Union. But Norris McWhirter produced that paper with the aid of a young man called David Noakes. And in my book, which you so kindly bought, there is a chapter on destruction of Britain's economy. Destruction of Britain's economy. That's one of the things they want, not only to get rid of the sovereignty, get rid of the religions, they want to get rid of the economy and all the industry. Did you know, for instance, that Britain is lined up under EU to become a tourist state? And the farmers are going to give up their farms, look after the territory, and line it up to receive the tourists. They're not even supposed to be producing cattle any longer. Well, this destruction of Britain's economy tells you very clearly what the situation is in our economy, how much money is being spent, how much money is being wasted. Now, David Noakes began, to my knowledge, to produce that same sort of outspoken newspaper in harmony with Brian Gerrish in Plymouth. And now he's disappeared. And that's a paper which I miss very much, because he was able to, as a good journalist does, worm out the truth and print it quite clearly. And as a result, we learnt a lot of really what's going on in this country.
Thank you very much, Harry. I think the tape is just about out, is it?
Good.